Welcome back to our channel. Today we are going to discuss a very important topic, which is copyright versus trademark registration in India. If you are confused about whether you need a copyright, a trademark, or both, this video will clear all your doubts in a simple way. So make sure you watch till the end. In today's fast-growing digital economy, protecting your intellectual property is more important than ever. Whether you are a content creator, entrepreneur, artist, software developer, musician, or business owner, your work has value. But many creators in India struggle with one common question. Do I need copyright registration, trademark registration, or both? Copyright and trademark protection are often misunderstood because both fall under the umbrella of intellectual property rights. However, they protect different things, serve different purposes, and have different legal effects. This guide explains the key differences between the two in India, when each type of protection applies, and how they help safeguard your creative and commercial identity. Let's start with what a copyright is in India. Copyright is a legal right that protects original creative expressions, not ideas. The moment you create something and record it in a tangible format, like writing, printing, recording, filming, or coding, you automatically become the owner. Examples of works protected under copyright include books, blogs, poetry, music, songs, sound recordings, movies, documentaries, short films, photos, paintings, illustrations, designs, software, websites, digital tools, educational content, scripts, and training modules. Copyright gives the creator exclusive rights to reproduce the work, distribute copies, translate or adapt it, perform or display it publicly, and license or sell rights to others. Although protection begins automatically upon creation, official copyright registration provides legal proof of ownership, making enforcement much easier in case of disputes or infringement. Now, what is a trademark in India? A trademark protects brand identifiers used in commerce. It helps consumers recognize the source of goods or services, and prevents others from using a confusingly similar name or symbol. Examples of trademarks include a business name like Tata or Infosys, a product brand name like Maggi or Vivo, logos and brand symbols, taglines and slogans like "Just Do It," and even packaging styles, sound marks, or color combinations. Trademark registration gives you exclusive rights to use the mark, the power to take legal action against copycats, protection from others registering similar marks, and the ability to build and protect brand reputation over time. Unlike copyright, trademarks are about commercial identity, not creative content. Simply put, copyright protects creative expressions like songs, art, film, writing, and software, while a trademark protects your business identity like a brand name, logo, or tagline. So, what is the key difference between the two? Simply put, copyright protects creative expressions like songs, art, film, writing, and software, while a trademark protects your business identity like a brand name, logo, or tagline. Copyright protection is automatic, though registration is highly recommended for legal proof, and it lasts for the lifetime of the creator plus 60 years. On the other hand, trademark protection is not automatic. It must be applied for and is mandatory for enforcement. A trademark is valid for 10 years, but can be renewed indefinitely. The main purpose of a copyright is to prevent the copying of creative work, whereas a trademark prevents brand confusion in the marketplace. Which one should you choose? Many Indian creators assume they only need one, but the answer depends on the type of work. You should use copyright registration if you write books, blogs, poems, or plays if you create music, lyrics, compositions, or recordings, design original artwork, graphics, illustrations, or photos, develop software, apps, websites, or games, or create films, animations, reels, or other video content. You should use trademark registration if you run a business with a unique name, logo, or brand identity, sell products or services under a brand name, launch a YouTube channel, clothing brand, or online store, or if you want to legally stop others from using similar names or branding. Often, creators need both. For example, a song, film, art, book, or website content needs a copyright, but the artist's name, music label, or studio logo needs a trademark. Software code needs a copyright, but the app name or brand needs a trademark. If you are building a brand and creating original work, securing both gives you full protection. When it comes to legal enforcement, if someone copies your music, film, book, software, or content, copyright law applies. If they use a similar logo, brand name, or slogan, trademark law applies. Having registrations allows you to file infringement suits, seek compensation, request takedowns from platforms like YouTube, Instagram, Amazon, or Google, and stop copycats quickly. Without registration, proving ownership becomes complicated and time-consuming. In terms of cost, a copyright registration government fee is approximately 500 to 5,000 rupees depending on the category, and it's valid for your lifetime plus 60 years. A trademark registration government fee is around 4,500 to 9,000 rupees per class, and it's valid for 10 years but is renewable. If you are wondering which one protects digital content, the answer is both, depending on what needs protection. Digital content like blogs, videos, coding, design, and courses fall under copyright, while your channel name, brand logo, and domain name fall under trademark. Let's clear up some common misconceptions. Many people think that if they own a trademark, people can't copy their content. That is wrong. A trademark protects brand identity, not content. Another myth is that copyright protects your logo. Actually, copyright protects the artistic design, but a trademark protects it as a brand symbol. Finally, people think automatic copyright means they don't need registration. In reality, registration gives you legal power and proves your ownership. With the rise of AI-generated content, social media marketing, and global online selling, creative theft is easier than ever. Registration helps you protect your career or business, license your work legally, prevent unauthorized use, build long-term brand value, and maintain ownership even after death. If you are unsure what to register or how to start, don't worry. At VMK Professionals, we provide end-to-end services for copyright registration, trademark search and filing, objection handling, renewals, and enforcement support. We assist individuals, startups, influencers, artists, software developers, and businesses across India with fast, accurate, and affordable filing. Whether you are a creator or brand owner, VMK Professionals ensures your intellectual property is fully protected under Indian law with Pan-India service, affordable fees, and expert support. Both copyright and trademark registration play an important role in protecting your intellectual property in India. Choosing the right protection, or combining both, helps prevent theft, protect your career, and secure your future earnings. If you are a creator or entrepreneur, securing your work is not optional. It is a smart investment. That's all for today's video. We hope you clearly understood the difference between copyright and trademark registration in India. If this video helped you, please like, share, and subscribe to our channel for more useful legal and business content. Thanks for watching, and we will see you in the next video.